Hello, Peter.
Hello, welcome everybody to our pre-Christmas show, and we are here today. This is number 98. Spin Legal number 98 is December 23rd, 2025, and we're going to be doing a thing on libel and slander law. Okay, and this is one of these ones that has a fascinating history. And you know how much I love history.
Oh, yes, he loves history. Like, he actually used a case from 1215 in a tribunal case he had for landlord and tenant.
All right, moving on. If you need to contact Invictus Legal, you can do so at 905-688-5598. We'll be back open in the new year. And Angela's email is so angela@weareinvictus.legal, or mine is using peter@weareinvictus.legal. And the website is weareinvictus.legal. So our topic
any
today,
questions, anything, just send us both an email and somebody will answer.
Yeah. And our topic today is libel and slander. Okay. So let's quickly move on. So I love these history bits. Origins of libel and slander. Roman law. It's about civil actions, and I'm going to mispronounce this, acta inquarium, which focused on the intentional insult and hurtful feelings that a person
Injuriarium.
Sorry?
Injuriarium.
Injuriarium. Yeah, well, there you go.
Yep. And somebody insulted.
I don't promise to actually pronounce this correctly. I just do my best.
Insulted Julius Caesar. So it had to start somewhere.
I don't know that it was Julius Caesar, but it was a big thing in the Roman days.
Mm-hmm.
Right? Wasn't there a thing about slapping a person?
I don't know.
Wasn't there a thing about slapping a person?
Mm-hmm.
Right? I seem to think that was a thing back in the day as well in Roman law.
From when you say you're slapping somebody with a lawsuit.
Next one is English origins, is ecclesiastical courts back in the medieval days, and initially handled defamation but couldn't award damages. So it was victims often sought revenge through a duel.
Oh yes, the horses.
Yeah.
Those are interesting days. Remember, one of the first judges I appeared before talked about that.
Yeah, and then it was by about the 1500s, common law courts began hearing cases about reputation damages, accusations of crime and professional damage, right?
Mm-hmm.
Then we have the infamous Star Chamber of Henry VIII, who prosecuted seditious libel against where bad words said against the state, and defamatory libel where bad words were said between individuals. So those you have to go to the Star Chamber.
So people who are committing seditious libel, like how many people nowadays say bad things about our government? Would they all be sent to a Star Chamber?
So that would be every third person who writes a Facebook post, wouldn't it?
Yeah, exactly. Like
including myself half the time as well.
Yeah. Like how many of us have ever said anything bad about the government?
Yeah.
Any government.
Yeah. Yeah. Stick both hands up. So can you, Angela. You know that.
All of us.
Yeah. Okay. But of course, what happened under the rule of Oliver Cromwell in 1641, the Star Chambers were gone and common law took over criminal libel.
Mm-hmm.
Right. So basically, the rules stayed in place, but the courts changed.
Mm-hmm.
Right. Now,
criminal libel still exists. It's still on the books in Canada.
Yeah, but there hasn't been a prosecution under criminal libel for quite some time. In fact, actually, talking about that,
somebody tried to charge one of our clients with criminal libel.
Well, there's a famous case in India of criminal libel that took place in the 1850s that led to the alteration of the criminal code of India. And this is the Maharaja case. There's actually a TV series about this, limited series TV series about the Maharajas, and basically that TV series is about what happened. Is a particular Maharaja was prosecuting a lady for libel. No, slander, because criminal slander, because of the word she said about him, about how she said that he was supposed to be her foot maiden, and how what happened is that she was serving in more than a capacity of cleaning his feet.
Oh, I see.
Right. And that was, of course, libelous, slander. And criminal slander at the time was prosecutable under the criminal code in India. And as part of this particular case, what happened is eventually a whole load of other women stood up and said he did the same to me.
Ooh.
So the Maharaja took the state took the women to court, and then but the Maharaja, when he was giving evidence, was found to be a liar.
Of course.
Right? And it took, when you think about the position of a Maharaja who's up on high, he's one of the highest people of the land in India, and how it took for the brave woman who took him down.
Yeah, exactly.
That's a very brave situation to do that. But largely, there hasn't really been a conviction. Well, there hasn't been a trial for criminal libel for a long time. Right. Right. And moving on. Okay, so defamation protects individuals from false statements that injure, unjustly harm their reputation. And that's what defamation is overall. Now, libel is defamation
that's like there's attacking a person and their ability to operate in their profession, unless you can show it's true, or as their person or their personal ethics.
And again, for example, attacking Mr. Polyev and stating that he did certain things would be something that would be libelous if you were to do it in a written form. For example, a journalist who wrote a statement against Mr. Polyev that was found to be wrong, could be accused of libel and could pay damages for it today. Right?
Yeah, like there was somebody who wrote something like during the election, and it kind of attached Polyev to somehow bringing in a gangster into Canada, and who was found guilty in Colombia in that day, but he somehow managed to keep this person in Canada. I wrote them back and I said, take that out. We don't know that's true, because I don't think that that's proper to say about Polyev. Yeah. If you don't like him, that's fine. Say why you don't like him, but to make stories about them, no.
No, that's not on. Yeah.
Yeah. And the only thing I say about Polyev is that he has the word lie in his name.
Well, that's not his fault. That's just the way his name is spelled, right? Yeah. Okay, so libel is defamation in a written or permanent form, and written these days, when you think about it, what we're saying is in a permanent form because it's in a videotape. It can be therefore kept forever. Whereas slander is defamation in a spoken or transient form. So, for example, if you, I believe it's TikTok, which does not keep its images, is that, once it's viewed, it's gone.
Yep, or say it on TV. It's a broadcast.
Actually, TV is also permanent because the tapes are kept.
So if I went on TV and I announced through a bullhorn about something about Peter, I'm not going to repeat, but I did say it to him earlier. And what would that be called?
If you were just talking about, if you were just shouting, sounding, words out in the street, lies about somebody out in the street, that's called slander.
Yeah, slander.
If a TV interviewer comes up and puts a mic in your face and says, "Can you repeat that, Angela?" and you say it into the mic, that's now defamation, a libel.
Yeah, because you're defaming somebody.
Yeah.
And like politicians get to be a bigger target than others, but still there's limits.
Well, and
like we've all said things about politicians.
Yeah,
right?
Absolutely.
Like, you don't like their policy, you don't like their looks, you don't like their voice, you don't like their ancestry, whatever. but don't ever come up and tell fake stories about them.
Yeah. Criticize. That's why they say criticize their policy all you want, but don't tell lies about their background or, And again, if you were to say about a politician that, hey, he claims to be a graduate of the London School of Economics with a top-class honours degree, and you find out that he's not, it's open game to actually say he's not an economist, for example.
Yeah, exactly.
Right?
Yeah, exactly. And this is where you have to be extremely careful, and it does draw a thin line.
Yeah.
And in terms of criticism, that's why we have a free country. Yeah. We do have the right to criticize our government.
We'll come back in a minute. We'll come back in a minute to questions of democracy. But let's first look at basically the leading case in defamation is Grant versus Torstar Corporation. It's a 2009 case that came from the Supreme Court of Canada, and that set the conditions about what libel or slander is. So they're talking about the impugned words were defamatory in that they would tend to lower the plaintiff's reputation in the eyes of a reasonable person. Key factor there is reasonable person. Yeah. So when it's got to be what a reasonable person would see, not the plaintiff and how they see themselves.
Yeah, right? Say for instance, you're somebody coming into St. Catharines and you're moving into St. Catharines, and you hear all kinds of stuff said about our mayor and all kinds of stories that come out of school. And they're saying things like that, and you go, what? I heard all good things about the mayor before I came down here. And now I'm hearing all these crazy stories. Hey, should I be moving here? That could be an issue.
Yeah. So it's about what the reasonable person thinks, not what the slander labeled the defamed person thinks. Right. And that has to be something that there's rules about how that is dealt with within the court. So the words must be the words that must have referred to the plaintiff. Yeah. If you're talking about the mayor, right, and you say something about the mayor, who's to say it's the mayor of St. Catharines, the mayor of Niagara Falls, the mayor of Welland, the mayor of Fort Erie?
Yeah, which mayor? When?
Yeah. So you've got to you've got to be able to prove that if you're taking the case that the words referred to you. Right. Moving on, the words were published or at least said to one other person. So in the case of slander, hey, did you hear what Justin said? Blah blah blah. Right. That's good enough for slander. The trouble is, of course, with slander is that it's much, much harder to prove, because when it comes down to it, it's like, the person hears that Peter told Angela that.
What if the words of slander were put at a public meeting? Like somebody referred to somebody and insulted them incredibly and immensely as a professional person at a public meeting in front of others who are at that public meeting.
Yeah, and there now you've got a situation where maybe you have half a dozen witnesses. Yeah. When it's two people talking together and and a third person understands that they were discussing them. That's tough.
Yeah.
For example, you're in a meeting room at the bottom of the stairs, and you're talking about somebody behind their back. And I know that's something you and I would tend never to do, right? We would never do that. We're using Justin as the example here. So we were talking about Justin, and Justin heard us at the top of the stairs. So so those potentially could be slanderous words.
Yeah, exactly. If somebody says something to me, and then they say, "Oh well," and they said this outside of Justin's presence, but they said to me about Justin, yes, that's slanderous.
Yeah.
Because I'm the third person.
But again, we've also got to look at this fact that when it comes down to it, and this is where it particularly applies with public figures, that defamation exists in constant tension with charter rights that you get for freedom of expression, particularly under Section 2B of the Charter Canadian Charter of Rights and Freedoms, which is about the right of freedom of expression. There is a case of, how do you say about a politician, I believe that whoever, put in your least favorite politician, is going to ruin the country because whatever, right?
Yeah. During a very, very famous convoy, or I call it the Clownvoy, a protest up in Ottawa, people were carrying F. Trudeau flags and upside down Canadian flags. Right? And somebody had that, which included a vile, profane word in the flag. Yeah. And somebody got in trouble with bylaw people. But they took it that this was a charter protected right.
Yeah.
You can say that about a politician. F this guy. F them.
Yeah, and for example,
you're not telling stories about him. You're just saying F them.
Yeah, and your right of public expression about that, your burning of the flag, is all protected under the Charter of Rights and Freedoms.
So,
but when it becomes problematic is when you are talking about a politician, and there's that interplay between valid talk about a politician and defamate, putting that, accusing them of things that they wouldn't otherwise do. Jeffrey Archer is a key one here, because he was a politician before he became a writer, and Jeffrey Archer was sued one of the newspapers in Britain for defamation, and the thing was, their defense was the truth, and they were right. Because it was true.
Yeah, I read many books by Jeffrey Archer.
Yeah, I bet you have. Many, many people have. He's probably made more money since giving up politics than he did as a politician, but still.
Yeah. Okay. Good book writer.
So defamation, you've got to be very, very careful. There's that boundary between criticizing a person and defaming a person.
Yep. And you have to be really extremely careful. If I'm going up to you, Peter, and I'm at a public meeting and I'm very angry at you, I have to say, I am not happy with the way you did this or did that.
Yeah.
Because. But to go up and say, Peter is an a-hole because he did this, and he does certain things with pigs. Things like that. That would be almost slanderous.
Yeah.
Because the thing is, I have no proof he does anything with pigs or even cares or even thinks about it.
And even if your great aunt Jemima said it to you in the strictest of confidence, or her friends said it to you in strictest of confidence, it doesn't matter.
It doesn't matter. You have to be very careful. Okay? You have to say, okay, this is what bothers me, and this is what I'd like to have changed. The other person could say, no, I'm not going to change that. I'm going to continue doing it. If you don't like it, there's something called a door. Hey, maybe you could use that.
Yeah. And of course, with everything you accuse a person of, there's always a defense.
Always, yeah. Because somebody can say,
right?
You libeled me, you slandered me. Okay. Hey, and many people get sued for all sorts of things. We've actually filed libel and slander suits to ourselves, and so we've been able to do this. And there are some defenses out there that are fairly good ones.
Yeah. Well, the key defense is the truth.
Yeah. Like if you can prove that somebody is a prostitute, you could say this person is a prostitute, and just does it and they do this, hey, and they get paid for this, hey. And the thing is, they said, no, you're slandering me. But then I come up with proof, like I get sworn affidavits from a number of Johns that the person had, like to prove that yes, this in fact is true. So I mean, these are things that have to be shown. You can't just go out and say somebody is doing something or has been something just because you have a low opinion of somebody.
And there's an important thing about here is the defense of truth doesn't require necessarily absolute precision. Basically, what this is in relation to a case called Butiak versus Toronto Free Publications Limited, which is an SCR case. Basically, the court held that minor inaccuracies doesn't defeat the overall impression that they conveyed, that the truth was told.
Mm-hmm. Exactly. Like you were saying that the person wore a wig while they did it, but no, they didn't wear a wig.
Yeah.
They still robbed the bank.
Yeah. Yeah, essentially. So still the main thrust of what you're saying, that they robbed a bank, was true, even though you got the description of the individual because they didn't have a wig on.
Yeah.
Well,
yeah.
Right.
So these things, though, you may be missing the details or misapprehending the details.
And that's acceptable insofar as you're talking about a 69-year-old man, and you're thinking to yourself, well, most 69-year-old men are wearing wigs, especially if they've got what looks like a full head of hair. There must be a wig, right?
Yeah, Peter wears a wig too.
No, I don't. No, I don't. So the next one here is defense of fair comment. And a fair comment basically protects opinions, statements of beliefs, or inference based upon facts, upon true facts. So there's this is actually quite a complex area, and there is a case of WIC Radio versus Simpson, which is the 2008 case, which is the Supreme Court of Canada case again, where the Supreme Court. Pardon me?
I love going to the SCR cases.
Yeah, where the Supreme Court of Canada basically gave a unanimous judgment which reaffirmed that vigorous, even harsh commentary on matters of public interest should be protected, even if it's recognizable as opinion rather than fact. And the comment must be about a matter of public interest. And public interest is something that will be for the judge to determine.
Mm-hmm.
It must be based upon a fact. So it's not, so it must be a comment, not an assertion of fact, right? So a person makes a statement, and the person making the defamatory or alleged defamatory statement is making a comment based upon that original fact. Right, and they're not asserting a new fact, they're just basically asserting a comment. So the comment must be one that any other person could honestly hold based upon those facts that are shown before us.
Yeah, you may want to say, like, for example, that person who just spoke, he doesn't sound like he is an honest man. And you may want to give impression that there was a report last year that this guy, he said that he was going to do this, but he didn't do that. Some kind of based thing that kind of led you to have that opinion.
Yeah.
And but to go around saying, oh, that guy, I'm sure that he has his hands in a cookie jar, 24/7. No, you can't unless you know that there's something that could be close to factual.
The other issue is that the statement must not be made maliciously.
Yeah, you're making it. That's again the public interest thing.
Yeah, it's exactly because it relates to public interest. If you're basically making a statement where you're believing in, the words you make are based upon public interest, then there is no malice. But if the words you make are anger, that Angela lady, I don't care in the world. She doesn't know the first thing about X and Y and Z, and she's completely off the wall about this. I hate her, and now I make the statement that
or if they do things and you happen to be a competitor of that business and they're the same type of business, and you make
it could be conspired as
very detrimental to your competitor. Can't do that.
It could be conceived as malice, but not all competitor situations would be perceived as malice either.
You can say things like, how the Coke and Pepsi challenge, like they have things like that. Hey, stuff like that. When you see these commercials, hey, they don't necessarily show malice in them, but when you're going into and you're dealing with competitors, you have to be extremely careful how you publicly. This is why there's competition laws. Like I can't go on another person.
That actually is another
letters just because nasty articles, just because that person is a competitor of mine and I'd like to wreck their business.
Well, and that actually becomes another question because, in fact, actually defamation versus competition law is also very, it's
very fine line.
Very fine line there, so especially when it's competitors making statements.
Yeah, because anti-competitive practices also could be making false positive statements about yourself.
Yeah.
Okay? Yeah. Like I can say that I am an award-winning journalist and I've been doing this for 20 years.
Yeah, when in fact the only
journal and your resume shows that you've been doing it for 2 years and you haven't won an award.
The only award you ever got was your mother patting you on the back, so saying, "Congratulations for passing journalism school."
Yep, exactly. Or I got the skunk prize when I last did a bowling tournament.
Okay. So moving on to the defense of qualified privilege. Qualified privileges applies to communications and circumstances where the speaker has a duty of interest to make a statement and the recipient has a corresponding interest in receiving it. The leading case in this is Hill versus the Church of Scientology of Toronto, which is another SCR case, which explained that the defense exists to allow individuals to speak freely in social, legal, and moral duties, such as giving employment references, complaints to regulatory bodies, and statements made in official proceedings. So,
absolutely. Like you go off to my regulatory body, or you go to my golf club membership and all that stuff, and you say all kinds of stuff. I just want to have this person's membership revoked. These things are qualified privilege.
Yeah.
To make an accusation where there is some kind of quasi-judicial type of tribunal that you're writing to.
And the other thing here is that
what it said. Let the tribunal deal with it, and they'll toss out what's wrong.
And again, the defense, this defense can actually be, if it's motivated by ill will or improper purpose, then in protection is lost. And part of the challenge here is you're also getting, when you're talking about the Hill versus Church of Scientology, is actually, this is borderline what you would, what's that church slander? I lost the thread of it. What's pardon me?
That being a cult?
No. When you talk about when blasphemy, right?
Oh, blasphemy, yeah.
This is getting on the edge of blasphemy.
Casey Hill. Yeah, it's Casey Hill was.
Yeah, because Hill was not quite, but very close to being blasphemous.
Mm-hmm.
And the other question about this is, of course, that blasphemy really no longer exists in Canadian society today, does it?
Yeah, not as a legal term.
Yeah.
It might be still in a religious context, but not in a legal term.
Yeah. And it's not actionable in the courts is what I meant to say.
Yeah, exactly.
Right. So there's another additional thing that needs to be put up. Defense of responsible communication on matters of public interest. In fact, I'd be arguing in part that this is part of the original defense in qualified privilege, because it's similar. This defense was added by Grant and Torstar Corporation, and its test is that publication must be in a matter of public interest, and that the publisher must have acted responsibly in verifying the information, considering the factors and the seriousness of the allegation, the urgency and public importance of whether the plaintiff's side was sought and represented. This is where you hear these things of, we went to speak with Mr. Grant and he was not available for comment.
Yep. That's when you hear it. Rather than saying that, oh, this silly guy just refused to talk to us. Yeah. Oh my, can't say that.
So responsible communication. And you see, here's the question when it comes to matters of public interest. There's often an urgency with some of these, right? Because if you don't take action now, Mr. Grant could be elected as a new prime minister, and he shouldn't be, type thing, right? For putting that one in an example, or he may become now a new doctor when he's Dr. Death.
Oh yeah, there's a few.
For example, you know, I'm not saying anything in relation to this case at hand. I'm just saying that's the type of thing that is.
You just want to have some type published. Like, say, for instance, if somebody is a known pedophile and he's moving to town.
Yeah. Well, then you have to be very careful with some of this, because traditional journalists are taught this at school, at journalism school. Bloggers are not.
I know. This is why I really resent the way journalism is being put down as being fake and everything else, when these people are trained and they have editorial boards and so forth.
Yeah.
And a blog, I can just write whatever I want on a blog, and other people can just write whatever they do on a YouTube video or whatever.
Yeah.
That's wrong, you know.
Well, like, you think about
be responsible. At least if you're going to do that, be responsible.
Well, you think about it. If I'm a journalist and you're my editor, I put in a slanderous, I put in a libelous piece about George, George whoever, and you kind of go, "Whoa, it's very interesting here. He's got some interesting facts." And you talk to me and you say, "Have you proven A, B, and C?" And I've said, "Well, I've got backup for A and B, but C not so much." Now you as an editor will be changing the tune on some of the content of my article.
Yep. I'll be allowing you to talk briefly about A and B and eliminating any references to C.
Yeah, exactly. And the point also being with something like a journalist, a newspaper or a magazine journalist, is that not only is it the editor, but now the editor's going to turn around and say, "Hey, my lawyer, help me on this. I don't know enough about this. Can we publish it?"
Yep.
And then there's also
deep dive and do investigative journalism.
And then there's also the other thing to consider that will happen there, which is that they're going to actually say to they're going to pass it to the finance people, and they're going to go, well, I get it. It might be slander, it might be defamation, but hey, how many of our newspapers are going to get sold? Oh, we're going to make 20 million tomorrow by publishing this. We'll get sued for maybe 3.
Yeah.
Okay,
It almost sounds like a lot of the British tabloids.
This is classic British tabloid territory.
Yep, exactly. Because I was thinking about the thing with Princess Diana and a few other things.
Yeah, exactly. Princess Diana, Jeffrey Archer. They've all been there, right? We've seen it all with those, but this is classic British tabloid territory, right? So some other things that are worth noting in respect of defences is that, and I haven't really put up a slide for these. There's defence of consent, right, where basically the plaintiff consented to the publication. This is actually a game where the editor calls up to the, oh yeah, Mr. Jones, I've got the, I'm from the, Daily Whatever, and we're publishing an article about you tomorrow, which says this and this and this. Is that true? And he says, yes, that's very true. Right? If he says yes, and you've recorded it or you put it in an email, bingo, you're ready to go, publish, because consent is, as much as truth is, it's an absolute defense, and there is no coming back from it.
Yeah, like some people say that there's no such thing as bad press, regardless. So, I mean, this is one of the things. You get more press like this, and hey, you got more better known.
Yeah, and in fact, actually, I'd say Donald Trump says that.
Donald Trump, because everybody bashes Donald Trump because they all know he's in the Epstein files and everything else, everything else, but he doesn't care. He doesn't seem to care.
Yeah.
Okay? So I think he just relishes off the publicity.
Yeah. The other question about this is absolute privilege. So, for example, if we made a slanderous or defamatory statement in Parliament, in the courts, or in a tribunal, there is no action that can be taken.
Yeah.
Right. If your case is proven, you can repeat it outside the court. Right. If you're, if it's accepted in Parliament and passed into law, it can be repeated outside Parliament. But essentially, that's again, there's an absolute privilege. So whatever you say in a court case or whatever you say in Parliament cannot be used against you.
Yeah. Exactly.
Even if it's wrong, even if it's absolutely wrong, it can't be used against you.
Yeah, because what they do, and that is up to a tribunal or a judge or somebody to decide if there's any validity to it. And the thing is also, too, when we hear stories about all these lawsuits being filed, like you see them in the papers or you see them in magazines about somebody sued this one for this such and such, and they're suing for X millions of dollars, it always says nothing of this case has yet been proven in court.
Yeah.
At the bottom.
Another one is innocent dissemination. This is basically whereby you're speaking to somebody, but you've actually written some words and somebody steals it. Somebody else publishes it. You, the defendant, had nothing to do with the publication of said words. Even though you're the author of said document. It was a private document that should have remained on your laptop, or it was I'm speaking about you to you, and somebody overhears what I said and they record it and release it.
Oh, that's like I get an email from Peter and he says all kinds of things about whoever. Some politician or something. And then I decide to say, oh, this is interesting. I'm going to go all over Facebook and say this.
Yeah. Exactly that kind of thing. Yeah. Okay, so defamation law in Canada remains plaintiff friendly, that's for sure. More so than the United States, and perhaps more so than the UK courts as well. But again, US doctrine requires proof of actual malice for public figures. And instead of presuming the falsity of the defamation, right?
Mm-hmm.
Canada basically is more protective of reputation than unrestrained expression. And that's kind of where Grant and Torstar are going, right? So that's kind of why they're there. That is there. And at the end of the day, defamation requires proof of basically defamatory meaning, the reference made, and the publication. Right?
Mm-hmm. And you don't have damages on a libelous claim, but for a slanderous claim, you do.
Yeah. Now,
because slander, you don't know, you got to prove it, and even if you got all the witnesses, you got to show that it's like if I just say something kind of interesting about somebody's manhood or something like that, and we say it at a party, like how significant is that? Because we always hear that. Right?
Yeah.
Start telling people stories about somebody's that they're being a thief or they're beating their wives or things like that, or something more serious than that, then that becomes more potentially damaging to the person.
And the other thing to note, of course, is that, for example, if you're making a defamatory statement in a Facebook group that has 4 members, and only 2 are active at any one particular time, the chance of you getting, you're not going to get hundreds of thousands of dollars worth of damage. You're probably only going to get $5, right? Whereas if you're active in a group which has got 50 million, listeners, and you make the statement in that group, you might get a large amount of damage.
Yeah, and it's very important to look at this in terms of impact, and also the test of the reasonable person.
Yeah. And the reasonable person test is actually, it's a very interesting one in law, because in fact there are distinct rules about it.
Are there such reasonable people out there? Where do we find them?
Well, and so it's important that actually we do come, that if you're in a situation where you're being sued for defamation, you do come up with, what your concept of reasonable person is.
Yeah, exactly. And also the court has very definite ways of defining that and laying out the boundaries for this sort of thing.
Yeah. And when it comes down to it, those Grant versus Torstar, which is about the basic how defamation law is applied in Canada. Hill versus Scientology, which is about the other WIC Radio versus Simpson, which is about the use of public interest, and the other one, Hill versus Scientology.
Scientology, yeah, that's an interesting one. Hill versus.
Yeah, this is about qualified privilege. Sorry.
Qualified, yeah.
Yeah.
Yeah, this is why a lot of people, they get this whole thing about qualified privilege. Like if you've been working for me and then someone calls me and asks me for a reference, I could say certain things. I can't say a whole lot of things.
Browne Smith.
I can't say a lot of things, but
yeah. Okay. One couple of things to finish off with is defamation requires
to be illegal right now. Yeah.
Okay. Defamation, as I said, requires proof of defamatory meaning, the reference, and the publication. Right. Yep. Now, moving on. Remember also that vigorous debate of issues of public importance is not just a right; it's a lifeblood of our democracy.
Yeah, exactly. Like we saw all the people going down with F. Trudeau. Okay, some of them even changed them to F. Carney, but I don't know. But people have a right to say things about politicians this is not implying they did anything horrendous or accusing them of any crime. Is just like almost expressing that I don't like this guy, for whatever reason, right? So, I mean, there is somebody who was actually charged by bylaw for flying a flag like that. There's a lot of things like that. And then there's people who go into different things and they say, well, I don't like the government. I just think the government should just bow down to what we want. Okay? People say that too. But when you start taking actions toward making that happen, that gets into another area of law, not defamation.
There's also another thing also to consider is that when you work for certain professions, there are rules associated with professional bodies like doctors, like lawyers, like accountants and the like, that actually govern the use of the courts in defamation cases.
Yep, exactly. Like, for example, if you are filing a complaint against a lawyer and you're writing the complaint in there, I mean, it's probably a lot of it may be untruthful or could be opinion and that sort of thing. But that's not defamation itself. There are other things that could attach itself to it, especially if you file a lot of frivolous complaints that way. But the defamation law itself doesn't attach because of the qualified privilege.
Yeah. Okay. And the same would be true if you were making a complaint against a doctor or anybody, or people in the medical profession, or even accountants, or even like engineers or something like that, where there's it's a certified profession.
Yeah, anybody there's a lot of them. How many professional bodies are in Ontario?
A lot, quite a lot.
They're all legislated, and they all have certain regulations, certain standards that they have to abide by. Hey, like if you're an engineer, you have a certain standard to abide by. If you're a doctor, you have a certain standard to abide by. And this is where you're saying if you're not following the standards, like applying to the profession is very different than if you're applying for negligence or something else like a tort. Hey, that usually goes to the court. But applying for profession under like non-professionalism, that goes through the body.
Yeah. All right. So I think that kind of brings us to an end here. If you need to contact Invictus Legal, you can do so on 905-688-5598. Email Angela through Angela@weareinvictus.legal, or myself via peter@weareinvictus.legal. And then I'm going to leave into Angela's favorite part.
Yeah. So what you've heard today on Spin Legal, whether it's this show or the other 97 shows in our series, is not legal advice. But if you do need legal advice, please contact a paralegal or a lawyer. Like if any of the things that we talked about today, defamation, slander, or anything, you feel that there might be something, give us a call. We can have a chat with you and talk to you about what it is. It's a very, very complex issue. And there's been things, I've won several cases before, and I've also defended other cases before. Peter has done a lot of work on this area of law. So he has a good grasp of this area of law. So this is where we could help you. But there's other areas we can help you too, as we've talked about in other shows. Just come visit our website, and then you'll see the kinds of things that we can do for you.
Yep. All right. Well, thank you, everybody. And we will be Merry Christmas, and we will be seeing you in the new year. And
January 6th.
January 6th, yep. So that'll be our next show. That will be number 99. And so we're closing in on the 100th show, which will be the second show of next year. All right. So have a great Christmas and New Year, everybody, and peace on earth.